Yes, Mr. Clayton.
Good morning, my lords, my ladies. I appear with Mr. Rowan Pennington-Benton. The first respondent is represented by Dr. Lloyd Barnett, Anthony Bullock, Wyden Daly, and Shadia Serju. Forgive my pronunciation. And the Attorney General by Mr. Daniel Feetham, KC, and Daniel Goldblatt. Two brief points to begin at the moment. There is a short supplementary bundle which I think would have made its way to the board. Secondly, can I apologize in advance for my less than dexterous skills operating the computer? So if problems arise, may I get my apologies in first? Can I begin by saying that as a result of the various cases filed, the issues have significantly narrowed for the purposes of today's hearing. There are essentially two issues only for the board: whether the judge was entitled to hold that it was not open to Mr. Hart to argue grounds of challenge other than common law fairness because he failed to comply with the obligation to plead a positive case as required by Civil Procedure Rule 5674E.
Whether the judge was entitled to hold that it was not open to him.
Well, where the trial judge?
Yes.
Yeah. The trial judge, the way it was dealt with before the High Court was slightly different in this sense. We made a pleading point, which the judge did accept, but what happened during the intervening period was that the Court of Appeal in Charles reconfigured the pleading position in an administrative law case. So what happened, we referred in the first instance to a decision of Mr. Justice Cockram, which was just a straightforward pleading point. But once the case, as you know, in Trinidad, these cases take a bit of time to get to the Court of Appeal. Before the hearing for the Court of Appeal, in a long judgment, the Court of Appeal said that there was a mandatory, in a case called Charles, that there was a mandatory obligation to plead a positive case under 5674E. So the answer to Lady Rose is that, strictly speaking, that point, the pleading point was raised below, but not in that form, because the Court of Appeal, subsequent to the first instance court, reconfigured how both the basis for how the case should be pleaded in a judicial review case and the provision that was relevant to that. So,
but the short of it is that the judge found that Mr. Hart, it wasn't open to Mr. Hart to assert in a case of fairness, and you say that the Court of Appeal is wrong to overturn that.
Exactly so. Yeah, exactly so, my lord. The principal reason for just dealing with a pleading point, first of all, is that as a result of the failure to comply with the obligation to plead a positive case, we had no opportunity to deduce any evidence in relation to the legitimate expectation claims said to arise out of the 25th of April letter of 2016, or indeed Rule 43. And the reason we say that is neither of those two obligations were raised until the written submissions, which was long after we filed evidence. And the second issue we say arises...
That might be a point to make in relation to the legitimate expectations argument, but it doesn't go to the common law fairness argument.
No, I accept that, but it does go to the import of the rules. We're going to say, can I deal with the point my Lord Legate raised by saying how we deal with the second issue, which that we submit that the trial judge's conclusion was fair in the particular circumstances of the case, and the Court of Appeal erred in disturbing the learned judge's conclusion. And so that we're clear on that, I want to just make three other preliminary points.
Sorry, well, just before you move on from the big issues, going back to the first issue,
Yes.
what did happen in the Court of Appeal? So was there an application to introduce new grounds which had not been permitted to be run by the judge?
No, what happened was that the judge, I was going to come to that very near the beginning.
All right. But spare it till then, that's fine.
All right, okay, thank you very much. I just wanted to deal with a couple of preliminary points, really. In our submission, the criticisms about the Court of Appeal's approach to the pleading points, and I will come back to making my point in a minute, really isn't a question of what some might characterize as arid legalism, because we make the point that neither the letter of the 25th of April 2016 nor Rule 43, or indeed the rules of procedure, were raised in the leave application or in the Mr. Hart's affidavit. I've made the point about disabling us from setting out our own case on those 2 points.
But the common law fairness doesn't depend on the letter or the rules. It just it's enough, just the basic duty to give the person the opportunity to answer the findings before you make them.
I accept that. I accept that, but as I say, our submission will be that on the facts of the case, the judge's approach is correct. And obviously, the board may take a different view, it may not, but that's the position that we're in. And that's the position that I'm going to argue. And as I was indicating, we were suggesting the Court of Appeal misdirected itself because it substituted its views of fairness without addressing, and I'll make this good in a second, the claimant's, the Commission's pleading point as an issue in the appeal. It was neither dealt with as an issue in the appeal, nor indeed properly in the judgment, which I'll come to in a sec. Given that omission by the Court of Appeal, it gave weight to the letter and to the rules, which were never pleaded. Also, we make the point that in relation to the treatment of the judge's views on fairness, the Court of Appeal failed to look at the High Court's judgment as a whole, because there are quite a lot of findings.
But isn't fairness, that's a legal standard? I mean, it's either right or wrong, isn't it? And you sound as though you're criticising the Court of Appeal now on the second of the big issues that you've identified by sort of substituting their view for that of the judge, almost on a discretionary, as though it was a discretionary decision by the judge. But isn't the standard of fairness a legal standard? The Court of Appeal can simply say that, in our view, the standard of fairness is as we describe it, and the judge was wrong to have come to a different view.
Yes, but I was dealing with I quite accept that it's a matter for the court. All right, so I do accept that, obviously. However, what I'm saying is that the specific point I was making was the reference to the legitimate expectation based on the letter and the rules, which figure very prominently in the Court of Appeal's judgment, were simply not raised, and that was...
But are you seriously arguing that the natural justice point wasn't pleaded?
No, I'm not.
You're not? Good.
No, I'm not.
Because it seems to me clearly there, and black and white terms on the fixed date claim form, point number 1.
I accept that. May I make 2 points in reply? First is, whilst I'm prepared to undertake difficult submissions, that's not what I'm undertaking today. The second point I want to make, and this is really the crunch of our pleading point, the 2 sentences in the affidavit, which I'll take you to, go nowhere near enough. It really goes nowhere near enough to say that the case has been properly pleaded so that we are alerted to what...
You don't need to say much more. If your say is, I never had a fair chance, I was never given the opportunity to comment on the findings before they were published, then you know what the case is, don't you?
Well, with respect, that isn't right because the case requires a little bit more information because of this. If it said, as the Court of Appeal do, there was a legitimate expectation, then you would have thought we would have an opportunity to say that legitimate expectation doesn't exist because of Rule 8.
I understand that if you get to legitimate expectation.
Yeah, yeah.
You only need legitimate expectation if you don't have a right anyway.
Well,
just as a matter of natural fairness.
my lord,
To know what the findings are proposed to be before they're made.
I accept that. However, my point is, and I'm proposed to make it, is that it is a question of law for the court. There are, the judgment of the first instance judge is sufficient for our purposes when you take into account the position that Mr. Hart was in fact taking. And there's just add an air of reality to this case. In this case, Mr. Hart said, I don't remember anything about this. That's actually what he said. And so far as he had a positive case, the positive case was raised in other parts of his claims. For example, he said, well, I'm the chairman of the board, but I didn't have any legal or factual responsibilities. That was rejected by the judge.
Well, he didn't say much because he never gave evidence.
He's never said anything.
Well, in that case, you had to give him the opportunity before you made the findings.
With respect, my lord, our submission is that applies Occam's razing a little bit too quickly. What we're entitled to is an opportunity to deal with points as raised by the defendant, and if the pleading point is right, my lord, we would be content to say that's the end of the case. And with respect, the pleading...
I'm sorry, I don't see how you could say, if the pleading point is right, that's the end of the case, for the reasons that my lord's been putting to you. The natural justice, common law natural justice fairness point was pleaded fair and square.
Yeah.
You lost on it in the Court of Appeal.
Yes.
Unless you can persuade us that the Court of Appeal was wrong on that point, you're going to lose this appeal. So
that's your ground too, I think. You
yes.
say that in these particular circumstances it wasn't necessary to give them a fair chance to know odds of the findings before you made them.
Absolutely. So it seems clear that it's not sufficient for you, before us, to succeed on your pleading point in relation to legitimate expectation.
Sorry, I may have misunderstood something that I heard from Lord Leggett, but as I said, when identifying the issues, there are two. We accept we have to prove the approach was fair, and our answer to the approach is, in the circumstances of the case, we dealt with it fairly.
So we're getting slightly ahead of ourselves. Maybe we should let you develop your submissions on each of the two.
Yeah. Can I just briefly remind you before we step away from this, actually what the claimant, Mr. Hart, said when he, in the correspondence and indeed elsewhere. He says he has a very poor recollection of the events.
Where should we look for this?
Well, you'll see it particularly in the correspondence, which I'm going to come to. I thought it would be helpful at least to flag up the points.
Right, but can I just...
Page number.
Well, first of all, can you assist me? Why are you making these points? Are you saying that this somehow goes to the fairness, that because he was adopting this position, fairness didn't require him to be given an opportunity to meet the allegations against him?
No, what I'm saying is this, is the points he had were put before the judge, and the judge considered them and rejected them. They weren't part of the fairness case, they were part of other parts of his case he made.
Right, but if it's not part of the appeal that's constituted before us, why should we take up time looking at?
Well, because what it comes to is this, is that if you look at the judgment of the first instance judge, the first instance judge not only made a finding of fairness, but you have to look at the judgment as a whole, which deals with a number of additional points, which actually are the claimant's positive case.
Right.
He actually states what this.
I mean, there is a suggestion in your written case, I think, that you're making a submission you don't have to act fairly if the case is so hopeless that you couldn't have an answer to it. But there's a myriad of authorities that
No, I'm not.
reject that,
I'm not saying that. But what I am saying is that there are factors. I mean, I am going ahead of myself, but just so that I'm flagging up the point now, that the factors which Mr. Hart was in a position to make, given his problems with recollection of events some time ago, was that he says, for example, I was the managing director. Well, that's dealt with by the judge, and the judge says, well, that actually doesn't help you. There's no factual basis for your complaints about that.
Again, I'm sorry to pull you up, Mr. Clayton, but why are you going into these matters? Of what relevance is it to the legal debate before us?
Well, the relevance to the legal debate is the content of fairness depends upon the circumstances in the case. The content of the fairness depends on the circumstances of the case. In the circumstances of the case, unlike what the Court of Appeal said, referring to Cotton, well, it wasn't clear what the claimant's case was. In fact, it was perfectly clear what the claimant's case was. He said, I don't remember much about it, and this is the points I want to make about it. It was, some 12 years after the events in question. Right. So all we're saying is this, is that if one takes a realistic view of the case the claimant advanced and how he put it, those points were addressed by the High Court judge in the context of the case as a whole. And I'll take you to
they may be addressed by the High Court judge, but his complaint is he wasn't told what findings you were going to make and given the chance to comment.
Is what you're saying that they form part of the circumstances that have to be looked at to assess fairness?
That is exactly
really
right. That is exactly my point, my lady.
To assess what fairness required.
Yes. I'm sorry if I've not expressed it.
And I think you also say that actually, putting aside legitimate expectation, etc., those circumstances which influence the content of fairness should not be treated as including Rule 43 or the letter of the 25th of April, because those were not pleaded.
Yes.
So even ignoring the whole legitimate expectation side, when you're just looking at the common law fairness, you're saying you shouldn't take into account the letter and Rule 43 because those were not properly pleaded. We weren't given an opportunity to respond to those. And the circumstances do include other things he said, which the judge dealt with in other parts of his judgment, but reading the judgment as a whole, they're also relevant to his conclusion on common law fairness.
With respect, my lady, that's exactly our case. That's exactly our case. I'm going to move on slightly, if I may, to take you to how the Court of Appeal dealt.
Sorry, does that mean you're not going to take us to the references of...
It didn't seem... I was endeavoring to do that. It didn't seem to attract particular enthusiasm. We will. What I can assure you...
Well, if it's part of your case, you better show us the references you rely on. Sorry, I'm slightly mystified as to what you're now saying.
What I'm proposed to do is to refer to the particular circumstances at the conclusion of our submissions.
All right. Okay.
Thank you. Could I begin, please, by just looking at two parts of the Court of Appeal's judgments? The first you'll find it begins at page 41, is paragraph 5, if you could read that. And you'll see that none of those that does not include any issues about the difficulty over what we called abuse of process at that time. And then if we turn to later in the Court of Appeal judgment, which is at page The abuse of process, it says, paragraph 48, the argument, if you have that, the argument was made to allow the point of legitimate expectation to be used in the abuse of process. However, fairness, natural justice, and legitimate expectations were all clearly raised in the grounds and in the affidavit, and it refers to the letter and the reply. But with respect, that misses the point about what the obligation to positively plead a case is. It's not good enough to say you could find it if you rooted around for it. It actually requires you to plead a positive case. That's the essence of the submission to court. Perhaps I could ask us to look at, forgive me, so if I could ask you to turn to page 1142, which is the CPR in Trinidad. That is the area of the CPR which covers all administrative law cases, including constitutional cases. And I say that because of the Charles case. If you go to 56.1 at 1142.
Sorry, can I just check? Do we have the Charles case in the bundle?
You do. You have two, they're both in the Court of Appeal and in the Privy Council. And I'm going to turn to that quite soon.
All right, okay.
56.1, scope of the part, includes both judicial review and B, originated motion, that's a constitutional motion under section 14. I say that because the Charles case was a constitutional motion where the views were expressed. And then if we could go through, please, to 56.4. No, I'm sorry, that's wrong. Sorry, it's 1146. It's 56.7. And if you look at 56.7e, sorry, 56.7.4, it says the affidavit must, so it's obligatory, and then at E, it must state, E, the facts on which the claim is based. And the short point is that a two-sentence statement in the affidavit is nowhere good enough. And can I now take you to the Charles, as I said, before the judge.
Sorry, could you just give us the bundle reference to the affidavit? You've referred to these two.
I'm going to take you to the affidavit.
Oh, all right.
Thank you, sorry. But can I say that the way it was put before the trial judge, because Charles had yet to be decided, was his general pleading point, and that was in paragraph 23 of the judgment of the High Court judge. If I could now go to Charles, you'll find it at 1346, please. Actually, I think it may be 1345. Yeah, it's 1345. In fact, this is where the judgment begins. And if you could turn through to 1346, you can see that in the appeal, the Attorney General seeks to set aside the orders of the judge on the ground the decision of the judge fell outside the cases pleaded by the appellant. The central finding of the judge was that Mr. Charles suffered a contravention of his views. The contravention was wrought by the failure of the judicial legal service to ascertain the status of matters which had been assigned to the former magistrate before her elevation to the High Court. The board is familiar with this round of litigation anyways. But although we held that the concept of pleading was not pertinent to administrative law claims, which superseded the case that we put before the High Court judge on the same point, we nevertheless held that the claimant carried an obligation by the CPR, by the broader rules of natural justice, to adequately set out his case. And then their conclusion was on the facts of the case that had failed. And in fact, I then invite you, I'm just scrolling through, sorry, to read the reasoning of the court. Forgive me. It's 1360. I think. I haven't yet got.
So 1360.
Pleading issue.
Yeah, that's page 1360.
Yes, thank you. Thank you very much. Under the CPR, claimant must commence proceedings under Part 8 by filing a claim form, etc. The claim form and statement in case figures the process. Where proceedings are under Part 8, which we're not concerned with, you have a different procedure. And then turning to 1361, paragraph 54, all proceedings, however, are not commenced under Part 8. 55, one such genre is the claim in the administrative court under Part 56. This part encompasses judicial review and constitutional proceedings. Part 56 does not contain a provision analogous to Part 86. However, Part 56.7.4 prescribes the content of the affidavit in these terms. And you'll see, if you read it through, that it begins by the word must, so it's obligatory. This is.
Well, it's what you've just shown us, is it, the rule?
Yeah, this is the rule. And 4E, the facts on which the claim is based. And then picking up the analysis or the holding, accordingly, a litigant who approaches the court for relief under Section 14 must state in his affidavit the grounds on which the claim is based. 57, historically the affidavit was seen as distinct from pleadings. Nevertheless, under the CPR, one finds the affidavit performs a function of pleadings in that it is required by Part 56.7.4 to set out the grounds upon which relief is sought and the facts on which release is based. 58, one therefore looks to the affidavit to ascertain the case to be answered. The rationale for this rule, as for the more stringent Part 8.6 rule, is to provide the opposing side with notice of the case which has to be answered. It is a rule embedded in the requirements of natural justice, and accordingly it will be unfair for the court for a judge to decide a claim on the basis of material that was not set out in the affidavit. So those are the principles which are set out about pleading in administrative law cases. I should then take you, I think, to Charles and the Privy Council, just to explain our approach to that. In our submission, the Privy Council basically do not disturb the principles described by the Court of Appeal, but say the Court of Appeal misapplied the principles in the particular case. I'm afraid I can't remember offhand whether any of the board sat in the Charles case, but that perhaps doesn't matter terribly much. It's at the very end, so if you just give me a second to try and get to the right page. It's at 4946. And actually, fortunately, it's in the a report, so you can look at their thumbs. It's again part of this unending sequence of events which arose out of the appointment of Heir Caesar and so forth, which everyone familiar with Trinidad is familiar with that. And the first, if you read the head note, it's the first holding that covers the point. And then I'd like to go to 4956. Do you have that?
Yes.
The issue is described as, did the Court of Appeal err in holding the judge found for the appellant basis which had never been advanced in the pleadings? And essentially that the Privy Council say the Trinidad domestic courts got that wrong. If you could read paragraph 42 through to 48, please.
You want us to read those paragraphs?
If you would, please.
Yes.
And the submission we make about the Privy Council case is that the principles the Court of Appeal set out are not in any sense rejected by the board, but that they say they were misapplied to the case itself. So our submission to the board is that the Court of Appeal's approach to pleadings in the Charles case remains the statement of principle.
What do you understand in paragraph 48 of the Charles judgment? It says, on a proper analysis of his judgment, this is the trial judge, he did not find for the appellant on a substantive basis which had not been advanced in the pleadings or in the evidence. What does it mean by on a substantive basis?
Well, I think what he means is that there were specific factual omissions for which the appellant was criticized in the Court of Appeal, and the board took the view that those factual omissions were irrelevant and that they had satisfied the principles set out by the Court of Appeal.
Its meaning, is it that you have to know that it has to be pleaded the substance of the case, but not necessarily every tiny aspect?
Exactly. I mean, I'm not trying to set up Elysian standards, but I am saying that you do have to. Well, I'll develop the point in a second, actually. But before I do that, I want to really make this point. In our submission, it is telling that neither the Attorney General nor Mr. Hart ever addressed the Charles cases, or did the Court of Appeal. And that, with respect, significantly undermines, in our submission, the position adopted by the Court of Appeal. Okay, now what I'm next...
So this is your sort of reverse fairness argument, that you need to be told what the case against you is and have a chance to answer it before the findings are made, really?
It is. It may not be the most radical submission I've ever made to this court, but it does, in our submission, come to quite an important point, which is, I'm going to develop it in a tick as to how I actually get to the answer I want to get to. But it is, with respect, important to the parties to litigation that they have a chance to put their case.
Right.
Yep.
That's all.
If I may say so, I think the board understands the functions of pleadings, and speaking for myself, they serve a very important function.
Thank you.
And I think
I'm going to try and avoid.
from the rule is, in substance, the affidavit serves as the pleaded case as well as the vehicle for introduction of evidence.
Exactly so. So what I'd like to do, if I may, is to take you to the passages both in the leave application and in the affidavit, which effectively mirror one another. Before I do that, you'll notice that the grounds which are set out in the affidavit, they're actually set out at 83.3 of the bundles, stipulates 7 of the 10 potential.
Sorry, which page of the bundle?
83.
83.
3. I'm not going to look at it, I'm just giving you the reference.
Yeah, but I want to understand the reference. So it's page 83 as well.
Paragraph 3.
Paragraph 3, yeah.
Right.
Stipulates stipulates 10.
What is the document at 83?
It is the claimant's leave application.
And is this the affidavit?
No, I'm going to come to the affidavit, but
Right,
what
so
I
this
want
is the leave application.
This is the leave application. The reason I'm looking at the leave application, which is I'm going to come to in a minute, is the way the case is put is exactly the same in the affidavit as the leave application. Okay? And having stated the grounds, the potential grounds, I would like to look at 87, which is again in the leave application. Perhaps I need to begin further higher up, actually. In fact, I should have taken you to 84, which you'll see are the facts which entitle the applicant to make the application. And then I want to go to 87, I think. Bear with me. Oh, sorry, I want to go to 86, so sorry. 86, if you look at Roman 15, this is the letter which the Court of Appeal say is a legitimate expectation. And I want you to see what the claimant focuses on.
So he did, in his application for leave, he did mention this exchange of correspondence in April 2006.
He mentioned the exchange of correspondence, that's right. But what he didn't say is, if you look at the letter, is that the final paragraph of the letter, which is said to be the legitimate expectation, no reference to that at all. He doesn't rely on...
He says the willingness of the Commission to make findings and recommendations adverse, which were also noted, which were contrary to the rules of fairness and natural justice.
Yeah, but that's...
What's wrong?
He says that, and I'm not quibbling with that point. What I am quibbling with is how the Court of Appeal introduced into the case a legitimate expectation which was never being identified or relied on by the claimant. That's my point. And I'm going to say ultimately, irrespective of the fate of the submission that the judge got it right on the facts, is that the Court of Appeal introduced into the case matters it wasn't open for it to introduce. That's the point. And then if I then take you to...
It seemed to me the more relevant subparagraph was 16,
Yeah.
which refers directly to the letter of the 25th of April 2016.
I'm sorry, that's my fault. You're quite... So, I'm so sorry, you're right, and I'm not. I'm for reasons...
But I think you would make the point that when they give a précis of the letter, they don't include the assurance, which was in the letter, that no findings of adverse findings of fact would be made without an opportunity.
Well, which letter was that had...
That is the letter. That's the relevant letter, the 25th of April.
The 25th.
Yeah, I'm so sorry. My Lord says it's entirely right. It's my fault because for some reason my markings on the pages haven't thrived. But 16 is the relevant paragraph. And then, sorry. Oh, dear. I was on.
Right.
And then if we go to...
But have we then got the headline point in Roman numeral 19? The Commission did not provide the applicant with notice of adverse findings of criticism.
I accept that.
You're accepting that that has been properly pleaded, as I understand it. It's the legitimate expectation that you say has not been.
Yeah, and also, I want to also say that nor was any reference ever made until the written submissions long after the event about Rule 43.
But are you saying that because he didn't say in Little Roman 16 that the 25th of April letter had promised that they would alert him to any adverse findings in advance, that then means that you were not on notice as the Commission from this pleading, either that he was going to rely on a legitimate expectation argument, or that as part of his unfairness complaint at Little 19, he was going to rely on that statement in the letter.
Yes. But can I say, I'm going to take you to the affidavit. This is actually the claim form, but it doesn't matter for practical purposes because the affidavit simply reproduces the very same language. But can I just take you to the affidavit itself, which is, you'll find it 94. At paragraph 18, at 94, the same description is made that Lord Sales corrected me about in relation to the letter of the 25th of April. It doesn't make any reference to an assurance.
Are you looking at now? Sorry.
The affidavit at page 90.
So you've just got the same in the affidavit as we have.
Yeah, you do, but since the affidavit stands as a pleading, I think I should
absolutely.
take you through it. Then it's paragraph 21 and 22, which is the very short description in the pleading of what's involved. So that we're clear what I'm saying, I'm not saying that the fairness argument can't be raised. That's obviously not the point. But we do say that there was no reference either to salmon letters or legitimate expectations or Rule 43. And we make the following submissions about that. First, that it is a basic principle of judicial review that the onus is on a claimant to establish a decision is unlawful in a public law sense. It's not on the defendant to establish that it's not acted unlawfully. Secondly, that principle requires the claimant's grounds, which is the language of, you referring to 57(4)(e), must specify the nature of the dispute he alleges, which is sufficient to enable a defendant to respond by adducing evidence. They have to be able to understand the case that they have to meet and to be able to adduce evidence. And next point reciting the grounds, thirdly, reciting grounds of challenge without more does not alert any defendant to how he should respond to any particular challenge. Fourth, and this in our submission is an important point, the criticism we make about the way it's framed in paragraph 21 did not provide me with the notice of adverse finding, has not given it any opportunity to be heard, to rely on a rather ugly phrase, but it's a pregnant negative. It doesn't state a positive case at all. All it says is, it doesn't state how or why. Now, I'm not saying that that excludes a fairness challenge, a general fairness challenge. I accept that. And also we accepted before the judge, doing the best we could, that it must cover a salmon case. And then when the Attorney General raised maximalization and so forth, that it might raise that. But what it doesn't cover is the points that the Court of Appeal laid great stress upon.
What legitimate expectation and Rule 43?
Yeah, exactly so.
Well, it's not just legitimate expectation, it's the promise in the letter of the 25th of April as part and parcel of the unfairness of not then giving him.
Yeah. My lady is right. That's the factual allegation, which is prominent in the Court of Appeal
Yeah,
recently.
so his case was, at the Court of Appeal, this was very unfair that you didn't provide me with notice of adverse findings or criticisms, and it's particularly unfair because of your Rule 43 and because you absolutely promised that you would do that in your letter of the 25th of April.
Yeah.
Yeah, that was his case then, and you say you weren't sufficiently alerted to that by the little reference to the letter in paragraph 18 of his
Yeah,
affidavit.
and can I flag up? I'm sort of slightly out of sync, so I hope you'll forgive me. In terms of a legitimate expectation, first of all, it is always open to a defendant to say there's an overriding public interest. Papanet makes that clear. It also makes clear, which is you might think is some significance, if you don't put any evidence about the overriding expectation, you automatically lose. The truth is that we had no opportunity to put in any evidence about there being an overriding expectation. And that, with respect, is an important factual matter for a defendant to be able to raise, irrespective of whether, however strong the arguments may be, and they were strong arguments in this case, but the point is fairness required as an opportunity to respond. To deal with a slightly different point, which is Rule 43. Leaving aside what Rule 43 means, it's important to appreciate, and we refer to this in our case.
Sorry, just before you move on to Rule 43,
Yeah.
Do you give an account of what evidence you would have put in, or indeed whether you would have maintained that there was an overriding?
No, what in our submission we don't know is the answer to that. Although you get some hint of some of the points, which from what we say on the facts, but we didn't get a straightforward opportunity to spell out the detail of what we wanted to say because of the way in which
You did make the point this would have prolonged the process. The
Yeah.
public wanted to know the answer. That kind of argument.
we do make those kind of arguments, but with respect, it's the kind of argument we would submit where the devil may be in the detail, and it's the detail which we've not had an opportunity to say. And just to, if I may parrot a point Lord Sells made in the course of argument, is a pleading, and if we haven't had a chance to respond properly to a pleading, that is a serious criticism.
I understand these arguments, Mr. Clayton. The irony of them when we come to the next part is telling, really.
Well, fortunately, my ability to foresee is not in operation.
But were these points addressed in the written submissions for the written submissions for the appellant before the Court of Appeal addressed these points? Is that right?
They were addressed in the Court of Appeal. And more importantly, I should say...
Well, and, sorry, just on, I'm sure you're going to show us, but were there written submissions before the trial judge, before the judge? I mean, were these points, although not put in the affidavit and in the application, had they been made by the time of the hearing before the judge?
Yes.
So,
Yes, they were.
So
right.
let's just clarify, which I think you might be talking about a
When?
different point. Are you accepting that the claimant's reliance on the terms of the 25th of April letter and Rule 43, were those points made by him in his submissions to the trial judge?
Yes,
Right, okay.
they were. And the point that we complained of at that time was that
They hadn't been pleaded.
And more, we've put no evidence in about it, precisely because they hadn't been pleaded. It's not just that they hadn't been pleaded, it's we hadn't any opportunity to deal with it. And what actually happened became worse, because we won on that issue before the judge, so they never were before the Court of Appeal either. But the Court of Appeal was not deflected from the course that it chose to take.
Well, all this just goes to show why there's no answer to the central complaint of unfairness in this case.
Well, no answer with respect, we respectfully submit, doesn't do justice to actually the position on the ground. But
No, well, you're coming
will
on to
hear
that, no
submissions
doubt.
on that. You will hear submissions on that. But I don't propose to be shifted from where I'm going by remarks which appear to us to overstate the position. And I may be
Yeah,
wrong.
well, all this is just dealing with the icing on the cake, isn't it, of the legitimate expectations and Rule 43 argument.
Yeah.
It's not addressing the basic substance, the simple point that there was no fair opportunity given to deal with the adverse findings before they were made, which is the mirror image, actually, of your complaint about the lack of fairness that you had in dealing with legitimate expectations.
Well, I mean, whether one characterizes it as a mirror image or not, we would say it isn't a mirror image because for reasons which I will demonstrate if I ever get
Well,
there.
sooner or later, you're going to have to grapple with it.
I've never suggested I will.
Right. Just to assist me, can you just give us the bundle references to the written submissions that were available before the judge for both sides?
Yes.
And the
Can you
notes,
just
the
get...
notes of appeal, and then the written submissions on the appeal? I'm not asking you to turn them up, it's just so that we
Well,
have-
can we do that during the short adjournment? Or would you prefer me to do it now? I can do it now. I can tell you.
There's a,
All right,
there's a
look,
document at 248 which says submissions of the commissioners.
Yeah, if we look at that, it's paragraph 15 to 23, I think. But let me just go to...
I mean, I
those
wasn't
are
particularly
right.
inviting you to go to them, I just wanted...
Well, but I
know
need
where
to,
they were
I'm
in the
afraid
bundle.
I need to go through them just to tell my lord.
All right,
Page
if you want to.
159 is the claimant's written submissions.
Yeah, and if... No, I want to go to our submissions to say that, make it clear that we took this point.
Well, I thought we were looking at whether the claimant took the point.
No, I think he accepts he did.
Well, yes, we know he
I
did.
know, but we wanted to see where, I thought.
I've taken you to... Sorry, where they
Where he
took
took the point.
about Rule 43 and so on.
And the letter of the 25th of April containing a promise.
So, well, the letter of 25th April, he never took the point.
Ah.
Ever.
Ah.
The person who took the point was the judge in the Court of Appeal when I was replying to submissions.
But at page 165 of the bundle, at paragraph 3.2, he says, very significantly, the letter of the 25th, 2016 stated, and then he sets out the bit that is actually the relevant bit for his point.
Yes.
Right, sorry, forgive me. Sorry.
And was this in advance of the trial, these submissions, or was it at the end of the trial?
They were in advance.
In advance, you
In
did
advance.
it before.
But it was certainly after we finished giving, we'd given our evidence. We'd given our evidence almost a year before. This was in September, and we filed our evidence on the case that was put, Mr. Farrell's evidence in January proceedings. So it was 9 months afterwards.
Okay. But I mean, I see at page 169 in this document, there's a heading, legitimate expectation,
And that's in relation to
and that refers to
the rules.
53.
But just so that we're clear, the criticism that we were making, and you'll see this if we go to our submissions, is, sorry, let me just, our complaints about the pleading abusive issues, where if you start at page 80, I think. 893.
Sorry, 893.
Yeah. No, sorry, I'm so sorry, that's wrong. That's my fault. So I'm looking at the Court of Appeal
I
document.
think it's round about 248 where my lady Simler said that, isn't it, that
Yeah.
your submissions were?
I think from memory, the paragraphs we deal with it are from 15 onwards.
Page?
249, I was told. Can I look at that?
Well,
Sorry,
it'll be
I'm
253 is paragraph 15.
Well, I think I think it's 178, isn't that? Oh, wait a minute.
Well, let me, sorry, I'm
ideas,
stuck in
but-
another. I was told at what page was I told?
Oh, yes, I think maybe.
My lady referred, I think, to
Oh,
178.
but that's,
The 158 is in the middle of the claim.
178, she said.
178.
That, well, it's after the fixed date form, the affidavit of Mr Farrell,
Yeah.
submissions
Yes.
of Calder Hart, submissions of the appellants. I assume those are before the High Court.
Yeah, what I was
So
referring
third
to,
and
they
fourth
begin at
defendants.
174, are submissions before the High Court judge.
Yeah.
And they, the complaint we make about the pleadings, in effect, start at page 176,
Yeah.
and they go all the way to paragraph 20.
Right, so the heading abuse of process is you're saying he is abusing the process.
Yes.
It's not dealing with his allegation of your abuse of process.
Put that way, okay, you're right. But what I wanted just to do is to see if you go, that paragraph, sorry, those submissions run all the way to 183.23, and at 23, paragraph 23 at 183, we make the pleading point expressly, which I mentioned before, the one which had to be changed because the Court of Appeal had expressed a slightly more complicated view by the time the case was heard by the Court of Appeal. So those were the submissions, and those submissions were essentially repeated to the Court of Appeal with the addition of the Charles case. Superseding.
Right, but you say that the trial judge accepted your...
He did.
yeah, right, so perhaps let's have a look at that.
Okay. He discovers them at, forgive me.
$20 perhaps is abuse of process, and that's it.
Probably. So what page are you looking at?
I'm looking at page 20.
Yes. Yeah. And he yes, that's right. So in it's paragraph 37 onwards, it's 37 to 49 where he deals with the submissions that were then made to him. And it's particularly the pleading point that we rely on before the board. Because we do accept that the grounds were pleaded, albeit, in fact, listed, I think, more accurately than pleaded.
The trial judge did think that the salmon letter point had been properly pled, is that right?
Yeah, I mean, we accepted, and you'll see, I'll come to that when I've nearly finished the submissions about the pleading point, but we accepted that the fairness point could be run and the salmon's letter could be run, and we also dealt with the point made from the Attorney General about Maxwellisation.
Right, but what you didn't want to deal with and what the judge didn't rely on because of he accepted your pleading point was the promise in the 25th of April letter or Rule 43.
Right. And I wanted to make a point about Rule 43, which I ought to make. I haven't made it before, I don't think, but it's important when looking at Rule 43 that under Rule 8, the Commission had a power to a power to abridge or change, or basically not apply the rule. And that would be something which, in our submission, the Commission might have wanted to respond to about Rule 43. But the truth
And
is,
they weren't at that stage arguing for a legitimate expectation based on the letter, anyway, it seems.
no, I think that's, yes, I think the legitimate expectation was solely concerned with the rule.
Yeah.
I think that's right.
Yeah.
Yeah, and the Court of I may be wrong, but I do remember the moment when, as an advocate, when the point about the letter was raised. Now, as far as I can recall, and I don't think it's disputed because I've put it in the case, it was raised by the judge to me in my reply.
In the Court of Appeal.
In the Court of Appeal.
The point about Rule 43 or the point about...
No, the point about the letter raising a legitimate expectation.
Yeah, the point only about the letter. And I mean,
was that, sorry, just to be clear, was that in response to your argument saying he didn't have a common law right to a Maxwell whatever,
yeah,
because he had not been a witness in the proceedings?
Well, it's, to be frank, I'm not sure what it was raised by the Court of Appeal, simply saying, well, wait a minute. I mean, if you look at the actual ordering of the judgment, it's very, very high up the batting order, the legitimate expectation. I think it's the very first.
But I can see logically that if you're maintaining that he didn't have a common law right to a letter because he had not taken up the opportunity to give evidence at the inquiry, then the Court of Appeal could have come back by saying, well, whether or not he had a common law right, you promised him in the letter of the 25th of April, so that raised a legitimate expectation. One can see the the to and fro going like that, but your recollection is that that may be a little bit more organised than what actually...
Well, there were many elements. It was a surprisingly quick hearing. We were told that there was no point referring to any documents because they'd read everything, and that was made very clear. The hearing lasted about an hour and a half, and there were 4 parties who gave submissions, and what I can say is that the legitimate expectation point was raised when I was replying, and as far as I'm aware, about the letter had never been relied upon in the terms the Court of Appeal said it was before.
Right.
I think that's right.
Can I just pick up one point? You mentioned Rule 43 and Rule 8.
Yeah.
So Rule 8 gives a discretion to depart from Rule 43.
Yeah.
And of course you had the written submissions from Mr Hart, I think in September 16, you had a couple of months to respond. Was it said in the written submissions for who's now the appellant that discretion had been exercised under Rule 8 or even Rule 9 to depart from Rule 43?
No. So that we're clear, and this perhaps is quite important. We didn't file evidence as a result of the written submissions by the appellant. Yes. We simply said, this isn't the way things should be done. We're entitled to know your case. If we know your case, we'll put in evidence. In fact, had they done that at any stage, we would have filed evidence. Had their affidavit ever spelt out any of the detail, we would have applied to put in an affidavit in response because it's a pleading. And we never did. And so, I mean, that may be important because I think part of the appellant's case is, well, if there was a problem, it was for you to address it. Well, with respect, that isn't correct, that it's for us to remedy defects in their pleadings. But there's a bigger point about that, which I'm sure those of us who've done public law cases are very aware of, is precisely how a claimant puts his case will vary from one claim to another. And although one likes to imagine one has reasonable foresight about what could be said, we actually didn't know what they were saying and precisely how they put it. And it's that level of detail, which certainly, for what it's worth, one would have expected to see in an English case, a more rather detailed description of a two-liner just wouldn't have done it in front of the English administrative court.
Well, I'm still looking forward to hearing how you're going to answer those sort of points when you come to deal with the natural justice argument.
Well, I can only say that I'm gratified, but I think really what I want to say is this, and this is really the point I was just making, is that when it comes to the case a claimant advance, it's not our job to identify an unarticulated challenge
No, well,
and address it.
speaking for myself, I have some sympathy with that. That's what pleadings are there to give notice to the defendant of what case they have to meet, and I think that's the point you've been making very forcefully.
Yes, thank you very much.
And it
just-
seems to me that, I mean, subject to anything further you wanted to say, you've now shown us the relevant materials, have you not?
Yeah, I think I have.
So do you want to move on to the second issue?
I can do. There are certain points. Can I just deal briefly with a couple of other points which...
Certainly, yes, whatever you think assists your case.
I just wanted to deal with the position about leave to argue new points, which is a position, there's a difference in the position adopted by the Attorney General and the defendant. But what's important in our submission is this. The Attorney General conceded below, before the judge, 2012 paragraph 1311, and before the Court of Appeal, 977 13.1.
Sorry, can you give those
give us-
references
yes.
again?
Sure. 212, paragraph 1311.
Is that, you said 2012 first
Before,
time,
yeah.
so
Oh, I'm
do
sorry.
you mean 2012?
No, it's 212. Sorry, I'm slightly
21.
dyslexic with numbers. I'm afraid.
All right,
Apologies.
212. And this
212
document is what?
13.1.
And then
And then 977 13.1.
Well, sorry, it's very slightly quick for me. Page 212, paragraph 1311. But what is
13.1, I thought.
1311.
13.11.
but what is this document? Just assist us.
This is the submissions the Attorney General put before the trial judge.
So these are the attorney's written submissions before the Mr. Justice Harris.
Correct.
Yes, thank you.
And then before the Court of Appeal, the same point was made by the attorney, and that's at 977, paragraph 13.1. The reason I meant...
Sorry, 1311 again?
No, 13.1.
13.1. It's 977.
it's only got 13.
I think it's 1311.
Is that your misreading again? So 977 does not have a 13.1 on it, but it does have a 1311.
All right, I'm sorry.
It looks like the same point. Yeah.
It is, I
This thing
think,
is just,
Cut and paste.
yeah.
it may be a cut and paste.
Right. Anyway, that's the paragraph you wanted us to look at.
Yeah, I did, because, and the reason I make that point is in the case before the board, the Attorney General changes their position and says he simply isn't going to make submissions on 1129, make submissions on legitimate expectation, and that's 1129 paragraph 52.
That's their written case, is that
That's
right?
their written case to my lord, ladies. And I want to make 2 points about the change of position before the board. The first is that, as we've already noted, the written submissions on Rule 43 were described by the claimant as a legitimate expectation in their arguments before the High Court. That was 169, paragraph 4.1. And the point we simply make is that, as a matter of logic, the criticism about lack of leave would apply equally to both legitimate expectation and Rule 43, and therefore the distinction which the attorney seeks to make is with respect, is difficult to sustain. I'm wondering, dealing with the second issue now, I think really our case comes down to a simple issue to begin with about whether we've satisfied common law fairness. And what I'm going to do is take you through the relevant principles, and then we'll conclude with the submissions as to why we acted fairly on the facts. On the, if we go to the High Court judgment at 50 to 53, that's page 165, I think.
Sorry, paragraph, do you mean paragraphs 50 and 50 to 53?
Yes, I do.
Yeah, I've got it, electronic bundle,
Yeah.
page 23, I think.
Yeah.
Anyway, I've got it in the
Right.
hard copy.
Yes.
Apart from bits blacked out on the right.
Yeah.
Now, sorry.
So page 23 of the electronic.
So can I just ask you to read it first of all?
What?
The judge's reasons.
Paragraph 50 onwards.
Yes, please, to 53. Those are his holdings in respect of fairness.
Well, I think the complaint is mischaracterised in the first sentence.
Well,
It's not that he wasn't given a fair opportunity to participate in the proceedings. He wasn't given an opportunity to comment on the adverse findings before they were made.
well, there are some. Let's just try and work this through. There are settled. First of all, we were trying to guess at what actually the claimant's case was as a matter of legal principle. Salmon letters go to witnesses.
Sorry, you've already told us that you knew that there was a case based on want of fairness and natural justice at common law.
Well, yes, but I want to make a couple of points about what legal principles are in play. There is common law fairness, we accept that. There is salmon letters, which is actually confined to witnesses. And then there are arguments about Maxwellization, which are about a completely separate process, which is giving notice prior to publication, so after inquiry, prior to publication. And in our submission,
But, I mean, aren't the second and third of those aspects of common law fairness insofar as there's a legal obligation attaching to adopt such procedures?
well, as I say, they might be in some cases, but not in all cases. I mean, it may be useful to remind oneself of the judgment that Lady Simler gave on commissions of inquiry. It's not quite as, I mean, it's a case which is familiar to the board because both Lady Rose and Lord Sale sat on the case. It's the...
You should never assume that I remember anything I've been in, so you're going to need to show me the case. If you
Okay, can we look at that for a sec? It's I think it's at 2005. 052005. Yeah, it's Myron. I'm afraid I'm.
Yandy.
And you see, at least I'm right on one thing. Lord Sales, Lady Rose, and Lady Simler, who gave the judgment, sat on that case. It was about a Mauritian Commission of Enquiry.
Yes.
It raised a lot. Can I just briefly summarize what it concerned and then take you to the relevant passages?
It would assist me if you stated the proposition of law that you say this stands as support for. And then
What I say is the key paragraph really is paragraph 6. The starting point is that procedure is primarily a question for the Commission itself. That's what my lady says.
Sorry, all right, which paragraph number?
Well, if you give me a minute, I was going to take you to it, but I'll take you to it. It's 2068. Sorry, forgive me. It's 2038. 2038. No, that's not right. Sorry. It's paragraph 68.
Paragraph 68, okay. Which I think is 2028.
Yeah.
Right, okay. Thank you. 202. 202. Yeah. That, with respect, sets out, at least as the starting point, which is, the starting point is, it's a question for the Commission. Secondly, other considerations apply other than fairness, effectiveness, speed, economy, and practicality. Thirdly, the standards of fairness are not immutable or identical in every situation. I think that's actually taken from duty. We must depend on the facts and circumstances of the case, the nature of the inquiry, the rules under which the Commission is acting, and the subject matter under consideration. Though it's impossible to lay down flexible rules, fairness is the standard to be applied by the court, but it's a flexible standard and must accommodate a wide and differing variety of circumstances, meaning one cannot be too prescriptive. So pausing there, if I may respectfully suggest that, it's not as straightforward an issue as my Lord Legate has implied, is that it's clear as a pikestaff what you have to do in every case. With respect, the board is saying precisely the opposite. And then if we go, there's then the discussion of duty. Oh, dear. Sorry, I keep on.
Paragraph 70 might be of some relevance.
Yeah, and then said, sorry, it keeps on jumping. I'm so sorry. It's because I'm not good with this stuff. Can I see it on your machine? Yeah, and then 70, as my lady says, and I think 71 is in our submission quite important as well, because it indicates that there's no obligation to give advance notice, but it's important to recognize the limit there is on that approach. So with our submission is this, is that the position of fairness is rather more nuanced than a cut and dry suggestion to say it's either fair or unfair. You have to look at the facts of the case and the way it's put. And I think probably...
Well, it may be nuanced the path to the conclusion, but at the end of the day, it is a binary conclusion, isn't it? Either fair or unfair.
Absolutely. I accept it's either fair or unfair, but the point that I am drawing attention to is that it's important to look at the facts and circumstances of the case.
Right. But, I mean, my lady raised paragraph 70 here. Paragraph 70, which essentially says if you're going to reach final, if there's going to be a public statement by a Commission of Enquiry, which seems to be making final or near final findings, the obligation of fairness becomes particularly demanding in that sort of situation.
Yeah,
and isn't that the situation we're dealing with?
yeah, all of which I accept. All I have to do is it's binding on you in any event, but I'm not. We're not going beyond anything that Lady Simler said on this occasion. And this is going to be, there are other issues, but it seems to me in the light of the submissions that, the points made by the board, that there is, we may as well cut straight to the chase about how and why we say it's fair on the circumstances of the case. And Mr. Pennington Benton is going to take you through the facts. Which
It's good.
well, there's much of stuff I'm not going to deal with in the light of the enthusiasm.
That's known as the leader's hospital pass.
Yeah. Oh, we're always very pleased to hear from Mr. Pennington.
Thank you very much, my lords, my lady. I've obviously been listening and can't deny a certain sense of trepidation at the journey I'm about to embark upon, but we do make the respectful submission that actually on the particular facts of this case, the learned judge was entitled to say effectively no harm done. I appreciate...
It just makes me slightly nervous when you say entitled to say. I mean, surely your submission has to be right to say, was right to say.
Yes. I say the judge was right to conclude that this is a case, in effect, where writing to Mr Hart would have made no real difference. And I say the Court of Appeal was wrong.
Sorry, I thought... I'm not going to stop you from making that submission, but just so as I'm clear, I thought Lord Legate had raised that very point with Mr Clayton, and Mr Clayton said that he was not advancing a submission, that this would have made no difference. It wasn't worth being fair to him because he wasn't going to be able to say anything.
Well, I don't think he's saying... I think there are two ways of cutting the same submission. So I have to say I'm a bit unsure myself as to whether it's a submission of makes no difference or it's a submission of, on the particular facts of this case, it wasn't unfair to write to Mr Hart because in fact he didn't really have anything to say, and what he had said he'd already said. I mean, can I just take your lordship to...
Right. I understood that you were going to be telling us what were the circumstances which could legitimately be taken into account by the trial judge and by the Court of Appeal as showing that it was not unfair that they didn't warn him in advance of findings they were going to make against him in the...
That's correct. That's correct. But if one looks at the Court of Appeal judgment where the relevant authorities are set out, paragraph 13 of the Court of Appeal's judgment, which is at page 49 of the bundle, my submission is that it tends to morph into, well, what difference would it have made? Because...
Sorry, it tends to morph into what? I missed what...
A submission about what difference would it make? Because one of the reasons we say it wasn't fair, indeed primary, amongst the factors that I will take the board to, is the fact that he didn't really, we respectfully submit, have anything to say or anything that he could have said. So that's why the submission that it's not unfair in all the circumstances not to contact Mr Hart does morph into a submission that it wouldn't have made any difference, which is you can see that morphing actually in this part of the board's judgment here, which is citing ex parte Cottam, the leading, or was the leading case on this point. And Lord Bingham, Mr Justice, no, Lord Justice Bingham, as he then was, sets out why it's a very difficult submission to make why it's a high threshold.
Right.
And I accept all of that, but my task nonetheless is to just highlight some of the salient features that the judge had in mind that we respectfully submit on the unusual facts of this case meant that it was not unfair. And of course, these submissions...
So just so that I'm clear, you're accepting that Cotton's, as cited here, sets the relevant standard?
I do.
Yes, all right.
And I accept that it's a high standard, and I accept that I'm going to
That's
find
the target you're aiming for.
That's
now,
the target.
The submissions that you're going to make.
It's a difficult target, and I accept it's going to be a rare case, but we do say that this is a rare case. Of course, these submissions are predicated on, to be clear, that there is no reliance on the letter and the Rule 43. But that does bring a very different complexion to the case, because, of course, if Mr Hart had been promised that we're going to come back to you, obviously that's
Right.
much more difficult to justify on fairness standards.
Well,
So-
not so much fairness. You'd have a legitimate expectation then.
Yes, but, but because the only relevance of the letter, and the only relevance, because the only way in which the letter can be relevant is if it amounts to a promise, the letter should just be disregarded, we submit, for the purposes of the fairness assessment.
As part of the circumstances which
Yes.
may have made it
Exactly.
common law unfair.
Exactly. So the real question we say before the board, which is not the question answered by the Court of Appeal, so that's one of the reasons we say that its fairness challenge can't stand, because it was obviously influenced by Rule 43 and the letter. But we say the real question before the board is, forget the letter, forget that he was allegedly promised anything, just think that he was asked to give evidence. What was his response to all of that? And then he decided not to give evidence. And then the inquiry went on to make a finding against him without going back to him. Was that unfair?
Yes.
And we would, I submit no. So can I just first of all remind...
And just to make the observation,
yes.
being invited to give evidence did not give him notice that the inquiry had in mind any such finding might be made against him.
My Lord, I accept that there is a difference between saying to somebody, here's the terms of reference, come and give evidence,
Yes.
and saying to somebody, here's some bad things that you did, here's some misconduct findings, what do you say about them? Completely accept that. But actually in this case, for reasons I'll come to in a moment, in this particular case, when you look at the terms of reference and take into account the findings that were made, the difference actually between the terms of reference and what would have been an allegation against him is pretty slight, actually. And that's one of the submissions I want to make. But can I start, please, just by reminding the board of the Commission's findings and the judge's holdings in respect of Mr Hart. Obviously, don't have time to go to all of the correspondence, but and all of the bits. But let me just start off with paragraph 77.29 of the report. That's at page 149. No, it's not. It's at 141. Apologies. So this is the fixed date claim form, but it's usefully got the bits of the report that are challenged, extracted and copied and pasted into it. So at 141 we can see...
Sorry, can I just check, are these findings not sufficiently set out at paragraph 11 of the Court of Appeal's judgment?
Seem to be a mix.
So page 46, paragraph 11, sorry, this is the Court
46,
of
yes.
Appeal.
These are
I thought they set out the relevant findings which were then going to be debated. I mean, by all means, show us something else, but I just want...
It's the same bits.
It's the same bits, so...
It's the same bits. I could show them. I could show your Lordship.
that's
Anyway,
fine.
I've just chosen to show them in the fixed date claim form. I can't promise. I can't really say why, but anyway, that's what I did. So
So at all events, the Court of Appeal has accurately set out the relevant factual findings in the
sorry,
report.
these aren't the factual... Those, yes, from the report, from the Commissioner's reports, but I just want to particularly remind the board of the finding at 7.29, which is the finding by the commissioners that Mr Hart had declined to cooperate with the commission by refusing to give evidence. And that's the particular finding. It's not... and then
that's one that he might have disputed, I suppose, if he'd been given the chance.
Well, he did dispute it in this claim, in this proceedings, and the judge rejected that and said, well, I agree with the commission. They're perfectly entitled to make that finding. That's got nothing...
That makes the findings true. It doesn't mean that
well, that's
their chance to answer it.
And in fact, 7.29 is one of the ones listed by the Court of Appeal.
This is one of the findings he sought to challenge, but my point is, this is simply about... This is not about the allegation. This is just about Mr Hart's position in respect of giving evidence.
Right.
So it's simply saying the commission reached a reasonable view that was upheld by the judge, that he had decided to be uncooperative, he declined to cooperate. It wasn't the case that, as he was saying, well, I needed X, Y, and Z documents and I needed to have my legal costs paid, otherwise why should I come and give it? It was actually the conclusion of the commissioners was that this person had been uncooperative.
But I mean, 7.29 goes on in the final sentence.
Yes.
The action and role played by the then managing director left UDeCott and HDC exposed to large losses as they proceeded to utilise land, and so on.
Yes.
So, I mean, that the first bit seems to be, I would say, have a tone of criticism of him as to the extent to which he was prepared to participate in the inquiry, and I think he would say, well, it wasn't an outright refusal. I think he would say it was a reasonable position I adopted. One could debate that. But the second part of 7.29 seems to be a direct criticism of him in relation to his action and role played as managing director of UDeCott and HDC.
Yes, well, I'll come to the specific findings against it, but I'm just sort of laying out the groundwork because one of the reasons we say, it's a cumulative case.
Right.
So we say there are a number of different factors that one needs to look at in assessing the unfairness or lack of unfairness. One of them is that the Commission had reached a fair view that was open to it, that he was not willing to give evidence. Now, I know that's not a complete answer, but it's part of the relevant background. It's part of the reasoning process as to whether you go back to Mr Hart and when you're about to make a misconduct finding, because you've got in your mind, well, he said effectively, I'm not going to be giving evidence, and the judge says, I'll just give the references, it's paragraphs 11 and 52 of the High Court judgment, pages 8 and 23. Because of time, I may have to speed up and give some references.
Yes,
but that's where those references are. Can I also give a reference to paragraph 68 of the judge's judgment, which is at page 28 of the bundle, in which the judge says, well, even if he didn't have documents, he could have at least come along and said something and explained his position. And then can I just turn, please, to paragraph 70 to 71 of the judgment, which is at page 29 of the bundle.
Sorry, which paragraph of the judgment?
Paragraph 70 and 71, please.
Yes.
Which is where the judge effectively accepts, well,
Yeah.
So I think in paragraph 70, the judge is, I think, indicating, or now brought to the attention of the court, second line from the bottom, that there's never actually been any indication from Mr Hart that he would even now be prepared to sort of step into the witness box. He's never come to court and said, oh, you know, I will file an affidavit, I'll come to court, I'll say anything about these allegations.
But he might still want to answer the allegations.
He may still want to answer the allegations.
In that manner.
He may indeed, my lord, by a letter or something like that. I accept
Yes.
that. And I'll come to that point in a moment. I'm just trying to get out way at the moment, the submission, we respectfully say, well, he was never actually going to give evidence. And it's important to bear in mind why Mr Hart said he would not give evidence and the terms in which he said he wouldn't be giving evidence. So can I just turn to the letter? There's a letter from his lawyers of the 27th of January 2016. That's at page 103. It's the main substantive paragraph beginning, unfortunately, my client is unable to provide any substantial information in relation to the terms of reference due to the fact that he's not in possession of any documents.
Are those the documents that he was asking
Yes.
to be provided with?
Yes, he was provided with what was available, 2 board minutes and a couple of other bits, but he was asking for more.
Yeah.
But it's important we say that he was saying, I'm unable to provide any substantial information in relation to the terms of reference. And we'll have a look at the terms of reference in a moment. But it's very important, he's saying, and the commissioners are entitled to treat him saying this at face value, that without these documents, which, by the way, he never gets, I cannot assist. Can I invite the board to turn to the letter of the 18th of March 2016 on page 120. It's the top substantive paragraph underneath Roman numeral 4. Third line down. Third sentence, in response to that invitation, my client indicated he would be willing to provide a statement, but having regard to the antiquity of the events, my client needed to be assisted. He needed the documents, and where necessary, to use its powers to obtain the documents. And Mr Hart made a separate challenge that was rejected and not renewed before the board, that the Commission ought to have summoned people or gone and used its powers to secure various documents to assist his case. And then, can I just invite the board to read the second from the bottom paragraph, where he says, not in a position to provide the witness statement, and cannot provide a witness statement unless he gets all of the pertinent information requested, and there's an agreement as to his legal costs, because he wants to be paid to come to the Commission to give evidence. And then at page 129, penultimate paragraph, I just ask perhaps your lordships and my lady just to read that second from the bottom paragraph, where the same point.
Is this a later letter or the same?
This is a letter slightly later on the 18th of April 2016, yes. And again, it's the unable to provide a statement. And
Presumably the last paragraph also has to be taken into account.
well, that then moves into the other issues about.
And so far as it goes to the other issue, but you can't really have it both ways, that you're saying that he said nothing to give the impression that he had anything, he was capable of saying anything in response to proposed adverse findings.
Can't I? Sorry, my lord.
Well, you can, yeah.
I mean,
I was intending to, but
it seems the basic gist is, as I understand it, he's saying, in order to give the fullest evidence, which will be of assistance to the inquiry, I would need to see the background documents, and if I can't have that, then it's going to be second best, to put it at its highest, as to what you will get from me. And I want to equip myself properly, so please provide me with the background documents. However,
Don't take that as a
if
reason
you're
to
going,
say...
if you're going to move to specific criticism, even if I don't have all the background documents by way of assisting me to give the best evidence I can, I'd still want to defend myself, and I would probably be able to say something, doing the best I can from my memory.
My Lord, I don't think I can... Respectfully, I think that is rewriting what he says. What he says is very clear. I am unable to assess. He doesn't say, I need these documents so I can give my best evidence. He says, you don't give me these documents, I don't give evidence, and you don't pay my costs.
Yes, you read it as saying,
What he says.
if I don't have the documents, I have no recollection. This was a long time ago. I have no recollection of this at all. There's nothing I can say unless you give me all the board minutes.
And that's why.
And you say, well, then he's hoisted by his own petard. If there's nothing he can say without the documents, he didn't get the documents. So what was the point of then putting the accusations to him?
That's about the size of it, my lady, yes. I'm going to add a few bells and whistles to make that
Well, obviously,
submission.
what he had to say in evidence, though, might not be the limit of what he would say in answer to
Well, that's
proposed
the
adverse
question,
findings.
That's the question. In my respectful submission, there's no difference when one looks at the terms of inquiry. And bear in mind, the first letter I took your lordships, my lady, to said, without documents, I can't assist with the terms of the inquiry. All of them. With respect, my Lord, he didn't say, oh, I'd like to give the best evidence I could. I'll come and help anyway without documents. He didn't say anything.
Just before we leave this letter, if you go over the page to 130 and see the paragraph at the top of
Yes.
that, I mean, it's a continuation of what he was saying in the last paragraph on the previous page. And essentially, he's saying, do put any allegations to me, obviously indicating I want to have a chance to defend myself. I can say something.
Well,
I may be able to say something depending on what the allegations are.
Yes, I accept he's saying, please still put the allegations to me, and there's a response letter to that, and that's the basis of the legitimate expectations claim that kicked off, as it were, in the Court of Appeal. I accept all of that. But what I'm just relying on, and I accept it relies on a strict reading of those letters, but in my respectful submission, they are strictly drafted. He didn't turn up and give evidence the best he could without documents. He just said flatly, I'm not coming. If you don't give me these documents, I'm not giving evidence.
Well, aren't you ignoring the last paragraph on page 129?
One has to read the whole letter to see what message it was giving. And it isn't that one can ignore the later reply to it, which is the basis of the legitimate expectations argument. But if any inference is going to be drawn as to his attitude, it has to be based on the letter as a whole, surely.
Yes, I accept it does, but nothing he says in the final paragraph there goes, in my respectful submission, to doubt the earlier statement that he has nothing to say in relation to the terms of reference. And that's going to be relevant when we come to look at the terms of reference, because the terms of reference, frankly, make it pretty clear what the focus of the inquiry is. And part of the background...
They do, but the thing is, they identify the questions to be answered. They don't identify what conclusions the inquiry had provisionally reached or finally reached in answer to those questions.
No, they don't. But in my respectful submission, he would have known, and make this point, he would have known that the writing would be on the wall. It's very clear. It's very clear. I mean, we will come to those terms of reference. Can I just, at this point, make the submission that the findings against Mr Hart are quite narrow. There's quite a lot happened on this project. The main and colossal problem, failure, was the fact that the land was unsuitable for multi-storey properties to be built on. It was an ex-quarry, and once the quarrying activities had been completed, it was just filled in and left. So it was inherently unstable. There was shifting land, cracks, holes, all sorts of stuff. It was completely hopeless to be built upon. That's the main failure. There was a load of other failures later, or alleged failures later. Once UDeCott, and then later HDC, when HDC took over the project, that once they realised that the land was unsuitable, they didn't take further steps. Mr Hart's not being criticised in respect of that. The criticism in respect of Mr Hart really focuses on the failure at the outset to secure a basic geotechnical report on the ability of this land to have high-rise stuff These are in the Court of Appeal as well, but my reference is that I've got my note to the fixed date claim form. But very, very briefly, at 140, page 140 of the bundle, main point here at 7.5 of the report is Mr Hart refusing to testify, but it does also make the point, that he was the mind and management of UDeCott, which is one point that he objected to. And then in the next paragraph that's challenged is paragraph 6.6. Mr Hart was the chairman of the board and therefore was fully in charge of the project. No evidence to suggest there was any inquiry made into the condition of the land.
Should you really be airing all these complaints, given that the issue before us is whether these are fair, these findings?
Well, my respectful submission...
We've all read, I think, the passages that he complains about.
It's presumably all been published, this report, ages ago, and what good this proceeding will do him is another question. But
well,
pursuing it.
The reason I'm going through these is to make the submission that these are not far-ranging misconduct findings against Mr Hart. They effectively focus on the failure to secure a report before agreeing to purchase the land. No report at all.
But what conclusion do we to draw from that?
Well, the conclusion that the inquiry drew that as the chairman of the board, he failed, as did the other directors, and they all got criticised in this paragraph in the same way. He failed to ensure that it was tabled to resolve to go and get a report before you purchase the land. In other words, this is an SPV. Its sole purpose in the world at this stage is to purchase a piece of land that you can build high-rise, affordable housing for people in Trinidad and Tobago without much money. That's the sole purpose of it. There's no doubt, we've got references, but there's absolutely no suggestion that the question of what land to purchase and the question of what reports to get before you purchase the land was a board-level question. And every member of the board, including Mr Hart, is found to have failed in the most basic obligation of any purchaser of land, let alone...
Right. I'm failing to follow how this assists your case on the appeal. You seem to be emphasising how serious were the allegations that were found to be made out in the report. Doesn't that lead into the importance of the obligation of fairness and that it be fulfilled?
Well, I think the submission that I intended to make was that what in reality could a director of a company, the chairman of the board in particular, possibly say to explain or justify or shift the Commission's view that it was a breach of fiduciary duty or duty.
But doesn't that take us back to the Cotton case? Don't speculate. Ask the person. What can you say about this?
Yes.
That's basic fairness. That's what Cotton says. You've emphasised the severe nature of the criticisms that are made of Mr Hart. He wasn't given an opportunity to respond to those criticisms. That's the essence of the natural justice case against you. Is there anything more that you want to say in the 4 minutes you've got remaining?
Well,
I mean, that is the essence of it, Mr. I didn't see that we should shilly-shally around that. We're giving you an opportunity to address that case.
I say that it's within the scope of the guidance given in Cotton and accepted by the Privy Council in that case to say that there are some allegations, such as these, that are just so obvious. There is nothing Mr Hart could have said. He's also had an opportunity in the 7 years in which this litigation has been running to give at least any indication at any stage of something that he could have said to possibly justify the colossal and just inexplicable failure to secure a basic technical report before you hemorrhage millions of dollars.
That is actually one of only 5 matters that they identified.
They're all come back to
Whether
this.
he could have said something in answer to why he didn't go and inspect the land personally.
Well-
It doesn't seem so obvious on the face of it that that is
Does it
a
say he should have?
dereliction of duty.
And they also say he should be accountable and liable for losses sustained in the execution of the project.
Yes.
That's 178.
But based on my understanding, that final point, based on the earlier finding that it was a failure, basically because all the other losses later flowed from the fact that you'd agreed to purchase a piece of land that was completely unsuitable, and you've allowed millions of dollars of taxpayers' money to be thrown down the drain on building on a piece of land without getting a basic technical report. And what on earth, respectfully, can a director, let alone a chairman of the board, have to say about that? And at no point, at any stage, and we've been running this point, exactly the same point before the High Court judge, before the Court of Appeal judge, at absolutely no stage has Mr Hart ever indicated what he could possibly say about that. The closest
No doubt they bought the land. There's no doubt there was no geophysical
no doubt.
report. There's no doubt he was the directing mind or whatever of UDeCott, whose job it was to deal with this. There's no doubt millions of dollars were spent. So you say he's never said why.
But I mean, that really is the source of the goose is source of the gander sort of point. Because when we go back to the submissions that Mr Clayton was presenting, it's never been said what answer would be given to the legitimate expectation claim, but still complaint is made that it wasn't properly raised at the relevant time. Speaking for me, for myself, I can see force in that, but why doesn't the same argument apply here?
I don't think the makes no difference point was run against us, but we are running it the other way round. We've always run it the other way round, and therefore
The irony that I noticed earlier, that the two submissions are making it diametrically opposite to each other.
yes, well they are, but in different scenarios. One is in a pleading scenario in a piece of litigation. Another one is to rubbish the findings of a carefully arrived at an important public inquiry at which Mr Hart had no intention of ever giving evidence, frankly, and had nothing sensible and could have nothing sensible to say about why on earth the company of which he was the chairman didn't get a basic geotechnical report. It's just hopeless. And at no stage has he ever been able to say anything to anybody in a submission or an affidavit or anyone what he could have said. And the answer is because he can't.
It does come down to the argument that Mr Clayton gave away before he put you up to it. The case is so overwhelming, there's nothing, you don't need to have a fair chance to answer it.
Well,
So
it's not unfair.
You meet the high threshold set in Cotton.
Yes. And I've got obviously other. I would like to just give some final references. I'm aware I'm on borrowed time, but
Yes,
my understanding is
you can borrow time from your reply.
Well, I actually understand that potentially Mr Attorney General might give way for 5 minutes of his time because he's got quite a large chunk of time. Sorry? I'm grateful, Mr Featon. Thank you very much. I literally, just to give the references.
Yes, of course.
Bear in mind, literally racing through these, 171, this is the rationality argument run by Mr Hart, that I wasn't involved in the minutiae of the project. We say, so what? He accepts at page 171, paragraph 6.2, that there was no board decision taken to get an expert report. He signed the deed of conveyance. That's clear from the report at paragraph 2.3310. So he says, I'm nothing to do with it, but it's him that's signing the deed of conveyance that actually purchases the land. And then
Sorry, what was the bundle reference for that? I'm so sorry.
Is that all page 171?
No, sorry, the last one was 310. So at 310, that's where the report makes it clear that the deed of conveyance was signed by Mr Hart. And then I was going to take the board to the terms of reference there at page 286, and I was going to emphasise paragraph 2, Roman 4, Roman 5, Roman 8, and Roman 9. And I was going to then refer to paragraph 64 to 65 of the judge's judgment, which is at page 26 of the bundle, where he basically says, well, look, the terms of reference are so appointed, you really must have known that at least this criticism, that you didn't get a report, was going to be coming, if not some of the others, but that criticism. And the point the judge makes at paragraph 65, that this is really a very, very narrow inquiry. The inquiry as it concerns Mr Hart is absolutely tiny. It's basically, he didn't get a report. And then there's a reference at page 116 to a letter dated the 7th of March 2016 from Mr Hart's lawyers. I think we may have looked at this one earlier, but in that letter, in our submission, the lawyers are saying that we may be prejudiced because of the terms of reference, and otherwise they recognise that the terms of reference in effect do make a form of allegation. Because they say, did the board get the right reports? Answer, no way. Of course it didn't. You can't read a term of reference that says, did the board get the right reports, as not an allegation that if you didn't get the right reports, you're in trouble. And of course you're in trouble, because how can you possibly justify purchasing a piece of land without getting a basic inquiry into it? And then finally, I just commend to the board paragraphs 2.3 to 2.21 of the report, pages 310 to 317, which highlight the real and obvious problems of the land that anybody, even a cursory report or investigation into it, could have identified. And we do respectfully submit that the Court of Appeal was wrong to overturn the judge, because the judge had made the findings based on an obvious appreciation of all of these important contexts and factual circumstances, whereas the Court of Appeal effectively says, come off it, the standard's so high, you don't make the grade. A bit like what I think with respect has been said to me as well whilst I'm on my feet. And we say, no, it's got to be a factual assessment, it's got to be nuanced, you've got to actually look at what happened on the ground. The judge did, and the judge got it right. And it's no good the Court of Appeal saying, well, this is all very good, it's an important principle, it's a high standard, all I have to do is cite Cotton and you lose. No, that's not good enough, we respectfully submit. The judge made a proper decision on this based on a full understanding of all these points. And although it was a difficult decision, I accept that, and it's a nuanced decision, just about, we do respectfully submit that the commissioners were entitled, given the unusual circumstances, the public pressure to get the report done, the fact it's already delayed, the importance of the inquiry for the general public, just to get on and get its report done. And that's the submission.
Yes, thank you very much. I think that we'll rise for a few minutes just to take stock of where we are. Thank you. Please don't go away. We'll be coming back. Thank you, Mr. Barnett. We don't need to hear from you. We're very grateful to all counsel that have been involved in making submissions and in preparing both written and oral submissions, and indeed in working in the teams preparing the case for hearing. The board will take time to consider their judgment. We will rise now. Thank you.